Hi, this is a short video where I'm going over an evaluation essay on omissions. An evaluation essay would appear on exam 3. Exam 3, remember, is where you'll answer one essay on criminal, one on tort, one on contract. So an essay on omissions could appear in the criminal section. This is an essay we've looked at in class. It's worth 25 marks and you would spend 45 minutes on it in the exam. So the question is, discuss whether the law on omissions strikes a fair balance between public policy and legal principle. Now I've put an image here of Diane Pretty because I wanted to draw your attention to the fact straight away that for an evaluation essay, whilst your knowledge of all the cases is important, that you actually get more marks on one of these essays for evaluation. You get 10 marks for AO1, 15 marks for AO2. And your AO2 is where you're analysing the law, you're evaluating it, you're saying whether it's correct, whether it should be reformed. So when I get towards the end of my essay, I will be talking about Diane Pretty. So that's a reminder there about how important your evaluation is. So however your essay on omissions is phrased in the exam, you're always going to start off with an introduction. And my introduction is that an omission is a failure to act, and the general rule is that a defendant will not be guilty through failing to act. Now you can see I've used two different colours here. Black font is AO1 marks, and you can see it's AO1 because I've just described what the law is. I've put in red font my AO2, where I'm analysing or I'm evaluating the law that I've just described. So here, I've said what an omission is, I've said what the general rule is, and then I'm saying that there is a reason we have this general rule. And the reason we have the general rule is that it is problematic to expect people to risk their lives to save others. And also there are practical problems in deciding at what point people should act, how many people should act, and at what point they've done enough. So straight away I'm getting my AO2 there. And while we're considering these two different colours, if we just scroll down through my essay, you'll see that a substantial part of my essay is red. And of course that is because there are more points for AO2 than there are for AO1. And I'm trying to balance my AO1 and my AO2 all the way through. So once I've done my introduction, I'm going to go through the cases on omissions. So we know that there are 6 exceptions to the general rule where people are expected by law to act. So the first situation is if you've got a duty through a contract, as in Pitwood. So I've said what the law is, but then more importantly, I've said that the case of Pitwood is justifiable because the defendant had been paid to perform a duty, and because he failed, he should be liable. I've also pointed out, though, that there are problems that it might not always be easy to say how much somebody has to do as part of their contract of employment. For instance, if there was a fire at Cronton College, how much would I have to do to get you out? So whilst we like the fact that you might have a duty through a contract, there can be some problems with it. Second exception is duty through a special relationship. So you've got Gibbons and Proctor. And of course, that case is telling us that parents owe a duty to their children. I've evaluated that there by saying that this is important because it enforces behaviour standards. Yeah, it's right that parents should be expected to act and look after their children. Third situation, Stone and Dobinson. So I've got some facts there. Notice I've kept them fairly short. Remember, the facts aren't what's important. It is the AO2 that's more important. So here I've said that Stone and Dobinson is a good decision because when people have voluntarily assumed to look after somebody and they don't, this is reinforcing behaviour standards. If you've promised to act and not done so, then you should be liable. And it's also protecting vulnerable people. Remember, the victim in Stone and Dobinson was a very vulnerable lady, so this rule protects people such as her. Fourth duty situation, we can see in the case of Dithan, where the police officer failed to act. Now, looking at the police, you could say that liability expecting them to act is justified because they are in a position of public trust. And of course, it promotes good practice. It's making sure that police are acting when they should do. You could also point out here that police will have received special training. So they're probably more prepared and well equipped to jump in and help in a situation than just a normal person who happens to be walking by. I could counter that by saying that perhaps it's unfair to expect more of those who hold public office because at the end of the day, they're only human. So it is fine to have arguments for and against. You will get credit for that. So moving on to our fifth duty situation, this is where the defendant creates a dangerous situation. So in Miller, he'd caused a fire to start, albeit it was accidental, but he allowed the fire to spread. My evaluation of that is that Miller seems to be a fair case because it's fair to expect people to act to minimise harm that they have created. Next duty situation is through an Act of Parliament. So it's possible for Parliament to create an act that requires people to act. So an example you could use here is the Road Traffic Act, and that act makes it an offence if you fail to report an accident and if you fail to provide a specimen of breath. The reason behind that law, of course, is that it is designed to protect society from dangerous driving and from accidents on the road. So what you can see I've done so far is I've gone through the 6 duty situations, but I'm not finished. I want to do more evaluation now at this point. So I'm explaining here that because we have these 6 duty situations, this illustrates that the law is trying to balance legal principle and public policy. And you'll notice there that I have linked back to the phrasing of the question. And it's good practice to do that as much as you can. I've pointed out that there are problems though, and there appears to be some inconsistency. And I'm going to talk about some other issues that come up in the law on omissions. So, first problem that I'm really talking about here is that there are problems in deciding whether someone should be liable for manslaughter where they fail to summon help. So Khan and Khan, Evans are cases that we look at actually in the topic of manslaughter. But in the case of R and Evans, for instance, the defendant there supplied her sister with heroin. Her sister injected the heroin herself and suffered an overdose. The defendant saw she was suffering an overdose and then failed to call an ambulance. And unfortunately, her sister died. Now, in that case, it was held that the defendant was liable for manslaughter through failing to act, through failing to summon medical help. Now, that's definitely fair enough in this particular instance, but it does raise questions about at what point would it be manslaughter in day-to-day life if you just fail to summon an ambulance? Again, I've put there, it's not clear how many people would have to act in a large-scale situation. I've pointed out as well that with rescue situations, you're putting the rescuer sometimes in great risk. And then another key area that I can evaluate on omissions is deciding at what point a duty ends. So in your booklet, that's called cessation of a duty. So doctors owe a duty to act for their patients, but there will come a point in time when that ends. They can't be expected to act forever and ever and ever. There has to be a line. Now, Airedale, Trust and Bland was the case involving Tony Bland, the 96th victim from Hillsborough. Now, he was on life support machines and the doctors were allowed to withdraw his treatment because it was said that their duty to act had come to an end because it was no longer in his best interests. In his case, because of his scans, etc., it was quite clear, I think, with him what was in his best interests, and his parents were in agreement with that. but it's not always going to be so clear cut. I would also bring in here what I mentioned before about Diane Pretty, that arguably there's a moral difference between a positive act and an omission. So in Bland, we said that withdrawing treatment was an omission, and that was okay. But with the case of Pretty in the UK, if Diane Pretty's husband had helped her end her life, that would have been a positive act, not an omission, and that would therefore be murder. But as you see there, William Wilson queries whether there's a moral difference between the two cases by pointing out that sometimes it's worse to fail to act and watch suffering than one who acts with a simple positive act. To me, it seems wrong, it seems illogical, unfair, that we can withdraw treatment here in Airedale, Trust and Bland, but we can't with Pretty in the UK. I could have also put another fairly recent case in here. In fact, I'm going to add it in now. We've talked about this in class, the case of Alfie Evans from 2017. I'll just put it in black and highlight it so it's the right colours. In the case of Alfie Evans, the case of Alfie Evans in 2017 was where, unfortunately, there was a very young boy, Alfie, who had suffered catastrophic brain damage and had been in a coma for a long period of time. The High Court and the Supreme Court, and in fact the European Court of Human Rights, ruled that it was lawful for doctors to withdraw treatment from Alfie. Now, unlike in the case of Trust and Bland, the father in the case of Alfie Evans disagreed about withdrawing treatment, and he actually believed that withdrawing treatment from his son was actually akin to murder, in his mind anyway. And this highlights a problem with the law, particularly when compared to cases involving a positive act, such as Pretty and Nicklinson. So as I was saying, that there is a real inconsistency here, that if you're withdrawing treatment, that's legal, but if you're doing a positive act, that is murder. And yet in both situations, the outcome is the same, death. And as we've seen with Alfie Evans, withdrawing treatment is sometimes seen as controversial in any event. So really important AO2 points to draw out in your essay here. I've then gone on to look at other countries. So France has Good Samaritan law, and I've explained what that is. And I've talked about the problems with having Good Samaritan law where you're expecting people to act. And this might be a particular problem in this country because we have a compensation culture. So if you're expecting people to act and then they make it worse, they could then be sued, and that is a problem. Lord Young would like to introduce Good Samaritan legislation, but he said we would have to change this compensation culture in order to do that. I've then gone into my conclusion here, highlighting what the problems with omissions are. And I think really what I would stress is perhaps the biggest problem at the moment is the line between murder and withdrawing treatment, and whether in fact euthanasia should be legalised. You could put that in there as well. I've ended with Law Commission suggestions, but as yet they haven't been enacted. You can see at the end here, I've then put a marking grid. We're familiar with this. AO1 marks here, AO2 marks here. So when writing your essay, when marking your essay, I'm looking for knowledge of the cases, excellent knowledge, clear, detailed, fully developed for the 10 marks, and for your AO2, excellent analysis and excellent depth on your AO2 comments. And that's the bit that students often do weaker on these essays. So hopefully this little video has helped show you exactly what you need to be putting in any essay that might come up on omissions.